Continuing to follow the developments in Washington after the leak of a Supreme Court draft opinion on Roe versus Wade. It suggests the High Court would overturn a federal constitutional right to an abortion. Final opinion hasn't been made, and votes could change before the decision is released this summer. It stands to be the most consequential abortion decision in decades.
And Suzanne Chand, a professor of political science at North Central College, is joining us now to discuss the potential ruling. Professor, first of all, let me get your reaction to this news and how you see this mobilizing political forces in its wake.
Yeah, I think there's two kind of distinct, although somewhat related things to think about here. One, of course, would be the overturning of 50 years of precedent with Roe versus Wade, and then its reaffirmation with Casey versus Planned Parenthood in 1992, and how that in and of itself would be enough to then sort of change those voters that typically may not come out in the midterms. They don't really see it as relevant or valuable, but could really push them to see this as an issue that is important enough to get them out and use their voice. And research specifically shows that young women who are pro-choice, that issues surrounding this, and this in particular, could propel them to participate in ways that they may not have otherwise. I think the second thing, though, to keep in mind in terms of what this does with political forces is the fact that there was a leak out of the one institution of our federal government that still had some reference and deference, that there was maybe something happening on the inside of that institution that was damaging or dangerous to someone who was inside of it in a way that they felt like they needed us to know what was going on. So what does that mean about whether we trust the law? Can we trust the law? Can we trust these justices? And so it throws us into a bit of a tailspin with that as well. And there's a lot of things that could be happening on with both of these instances I just mentioned coming into the midterms.
Because at this point, that is the most egregious part of this, the fact that there was a leak. And Professor, this is really not a done deal yet. We need to let folks know that. And how could that change? If it does become a done deal, it may not affect Illinois so much, correct?
Potentially, yes. So the first thing is that this process of an initial draft of an opinion being circulated, this happens with every single case. Of course, the leak is what has not happened before. Right. And so, yes, it is possible that the language may be shifted a bit. We don't know, or we suspect at least that Justice Roberts has not voted yet. He was not on the majority opinion. And so it could be that his vote is still up in the air. I would say based on the strength of the language in the opinion, it's unlikely that any of the 5 justices who've signed on are going to change their mind, or that a complete overhaul and overruling of Roe and Casey would not be what we see. But in Illinois specifically, because of who is in power at the legislature and in the governor's mansion, right now, abortion protections are there. However, elections have consequences. We've always known this. And all it could take if Roe and Casey are overturned is someone different in either of those branches for all those protections to go away.
Well, back to the national level. So Democrats and many others are fearing now same-sex marriage, transgender rights could all be under threat here. How do you see that playing out?
This is an incredibly slippery slope, especially if you read the language that's in the opinion, and if that's the opinion that is issued in June, that the right to privacy that Griswold versus Connecticut established and that Roe reaffirmed and then Casey reaffirmed, if the right to privacy is up in the air, we're not just talking about women's reproductive health. We're talking about healthcare for the trans community. We're talking about healthcare for other minoritized communities. We're talking about protections of basic civil rights and liberties like marriage and voting. If these are stripped away at the federal level, and if it sends a signal to other states and to other actors that this court is open and amenable to taking away federal protections and giving everything to the states, this could be an incredibly slippery slope for a whole host of issues.
So what does this signal to voters right now?
Well, I think, as I said before, it signals to voters that elections have consequences. We go all the way back to when Justice Scalia died and when Mitch McConnell would not give Merrick Garland a confirmation hearing. We fast forward through the Trump presidency and now into Judge Brown Jackson, who will take her place in the next session. That if this court is now going to be one that's judicially active and that looks to strip away precedent and direct policy, then we need to have some kind of say in who those judges are. Now, it wasn't always that way, and in fact, it wasn't designed to be that way, but if this is the way the court is moving, then the public has to meet this moment and make decisions for itself.
And in just a few seconds that we have left, if it gets overturned, it goes to the states. Can you explain what these trigger laws are and what would happen in those states?
Yeah, so what a trigger law says is that the minute something is signed into law, it immediately goes into effect. And so some of these states where they're waiting to see how the court would rule on this, and they're waiting to see if that law could go into effect, if this is overturned, those laws would immediately go into effect.
Professor Suzanne Chod at North Central College, thank you for your insight tonight. Appreciate it.
Thank you. Y'all take good care.
You too.
Well, new at 5, source